The appellants, particularly the Commission, faults the subordinate court on its findings on this issue.
Not the subordinate court.
Sorry, the Superior Court. My apologies.
Call it the High Court.
The High Court. Faults the High Court for finding that it was necessary that a legislation be in place before a referendum could be conducted. They rely on Article 257, Sub-Article 4, and wish that the court, after the comma, replaces the word which with the Independent Electoral and Boundaries Commission. And my Lord, this is an attempt to run away from the first limb of that sub-article, which requires that in addition to the draft bill, the promoters of a popular initiative delivers supporting signatures. It was conceded, my Lord, before you and my ladies, that the Commission does not have a repository of signatures. It was also conceded, my Lord, that there is no legislative framework for collection, presentation, or verification of signatures. Hence, the attempt by the Commission to fill that lacuna by adopting the administrative procedures they did, and which they say they used in the verification of signatures in relation to the bill impugned by the High Court. My Lords, my senior Eric Gumbo went at length to give the steps that the Commission took in verification, what they term as verification of signatures.
Is it verification of signatures or verification of voters, registered voters?
Our submission is that what is to be verified, my Lord, is the signatures belonging to the registered voters. You cannot have a signature without the signee. Now, what the law requires is that the person appending the signature, which is delivered together with a draft bill and called supporting signatures under Article 257(4), be registered voters. And so the Commission needs to undertake a process where it confirms whether what it has received as supporting signatures from the promoters are indeed signatures of registered voters. And our submission humbly is that if what the drafters of the Constitution intended was that the verification simply be that this name appears in the register of voters, it would have asked for a list of names of voters. It would not have asked for signatures. And indeed, my Lord Justice Kiage did ask what my senior counsel, Professor Guido Miguel, was it? I think Senior Counsel Tenda Molo was referring to as a unique identifier. How would the IEBC know that that name, for instance, belongs to Esther Angawa, who has appended her signature in support of the bill? And Senior Eric Gumbo read to the court the definition of biometric data, which is what our law identifies in elections law as the unique identifier, biometric, defined as unique identifiers or attributes, including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. of all the unique identifiers that would identify Esther Angawa to the commission, it is only signatures that appears in 257.4 as a requirement to be handed to the commission. It must be verified that those signatures belong to the people they are claimed to belong to. And it has been considered that there is no framework for such. In fact, Senior Gumbo went ahead as to say that to demand, he said that the court, the command of the court, and Senior Gumbo, if it wasn't you, please forgive me, it could have been any of the counsel for the appellants, my lords and my ladies. The submission was made that that command came from the High Court. It was not a command by the High Court. It is a command of the Constitution, Article 257.4. Demands that. The appellants took umbrage with the fact that the Superior Court referred to its treatment of verification of signatures in the Okoa Kenya initiative, and more particularly, that the High Court found it startling that the Commission was taking a completely different approach in this case on what it meant for them to verify signatures. My Lord, we urge this court to uphold the finding of the High Court on this question, and we urge you to be persuaded by what this court held in James Omingo Magara and Manson Onyongo Nyamoya and two others, versus Manson Onyongo Nyamoya and two others, 2010. It's at volume 1, page 187 to 210. The particular paragraph being at 199. And this is what the court said, that the verification of voters, in this case, and I'm sure, my Lord, the presiding judge are well aware, this being an appeal against your decision when you were a judge of the High Court. And the argument was that the verification of voters is simply a matter of math, or the votes that were attained. And this court held that verification of voters or votes is not a basic exercise, but a matter that requires beyond simple arithmetic ascertainment. The Commission submitted here that they ran the names through a program, the names. That is how they verified that the signatures they had received belonged to registered voters. And they attained the number 1 million, and that was enough. We humbly submit that the yardstick applied by this court in Omingo Magara must be the same yardstick, if not higher, for the verification of supporters of a popular initiative. Before I move to the next issue, my Lord.
So in precise terms,
yes.
How should that look like? How should that be done?
My Lord, let me begin by expressing my surprise that the Commission can come and state that it does not have signatures or unique identifiers of voters in this country, especially because we have a biometric system of voter registration. We have a biometric system of voter registration, and one of the unique identifiers under the Act are signatures. it is incumbent upon the Commission, and more particularly because of the fact that taxpayers pay for the work of the Commission. Taxpayers pay for the biometric voter registration. It cannot lie in the Commission to come and admit that it does not have that which it says in the Act is a unique identifier when we have a biometric voter registration system.
So I understand you to then be saying that the Commission should then look at each signature, each signature of the 1 million and then check that database and satisfy itself that each signature corresponds with that one.
Absolutely, my lord.
If I could just follow, are you suggesting that registered voters who do not have signatures cannot participate, cannot be the support an initiative under Sabbatical 1 to make up the 1 million, so that those who do not have signatures cannot participate?
My lord, it is not my suggestion. The Constitution demands that what is presented to the Commission are supporting signatures. If I do not have a signature as a voter, how would my signature end up in the list of supporting signatures to the popular initiative? Unless I'm not understanding your flow, my lord. You seem to ask what would happen to those without signatures, but the Constitution demands for supporting signatures. So if I do not have a signature, what will I be appending on to that supporting document?
What is the definition of a signature in law? You remember that in the Stanley Ngindo Matiba case versus Moi, that issue arose whether the petitioner who could not sign because he was paralyzed, whether he could present a petition. You remember that? Mm-hmm. So the question is, a signature is required. What is a signature in law?
My lord, I could write my name. It could be a scribble. It could be a thumbprint, if that is how I have, that is what I have indicated to the Commission, is what identifies me as that voter.
Okay.
When you retire, my lords, please do consider Volume 1, page 343 to 361. Professor Albert Stam on methods of state constitutional reform addresses the same issue, more particularly at paragraph 347. Now, my lord, before I move to voter registration, I think it is important that we look at the arguments given by the Commission for not being in a position to do what is demanded of it for lack of quorum. And particularly, my lord, because this bill, the bill that was impugned by the Superior Court, is said to be an initiative of the people. And the Commission has come and said that even though it doesn't have quorum, it can still create the administrative procedures for this process, and the court should indulge it, because the question of the membership of the Commission is not its fault. And I believe, my lord, you asked me, what if these things happening are not of the fault of the commission. And my lord, it is important to note that in Isaiah v. Watt, the judge said that he decried the late recruitment of commissioners, this lack of quorum being due to resignations. And I think it is important, my lord, for us, just before I move from that point, so that we can understand what the court is being asked to do here when it is asked to overturn the findings of the High Court. The commission, which concedes it has only 3 commissioners, is here saying it can still proceed to do what it needs to do despite the diminished membership. The Attorney General, who is the advisor of government, including the commission, is also here saying the same thing. Let's overlook that issue because it's not the commission's fault. The president, upon whom the responsibility to declare vacancies in the commission is placed by Section 7 of the IBC Act, is also here. Parliament, whose work is to oversight the executive, is also here, telling us to ignore the fact that there have been vacancies in the commission for more than 3 years and allow them to rely on their administrative procedures, which the commission conceded was supposed to be an internal issue and only came out because somebody wrote a letter asking, how are you going to do this verification? Never once has the commission, unless, because it hasn't made any submissions to that effect, stated what handicap there has been, why there has been no recruitment. Not once, not before the Superior Court, and not here. Their submissions were purely, ignore, we can still operate. In the country that we live in, my lords, it is important that we take notice of all those in power who ought to do their work within the precincts of the Constitution and fail to do so, but come here and expect the court to ignore all of that and assist them to continue down that road. Voter registration, my lord, paragraph 764 to 772 of the judgment deals with the issue of voter registration. Our submissions on this are very brief, my lord. Article 38, 3A and B of the Constitution gives any eligible Kenyan the right to vote. Article 82, 1C of the Constitution demands that voter registration be continuous. The Commission has submitted that voter registration has been continuous. Notwithstanding that the Gazette notice filed indicates that that is data as at 2019, 31st of December. My lord, young men and young women are still turning 18 after 31st of December 2019. old men, young women, middle-aged are still dying after 2019, 31st of December. And the law demands, the Constitution demands voter registration be continuous. The Elections Act, and the Commission read this to us yesterday, Elections Act, Section 5, subsection 1, provides that in compliance with the Constitution, registration of voters and the revision of the register of voters under this Act shall be carried out at all times. Before I move to the except, my Lord, we submit that there has been no evidence, not before the Superior Court and not before this court, that voter registration is going on or has gone on beyond the 2019, 31st of December.
I thought you were referred to an affidavit of Mr. Agoa, where he deposed inter alia that there has been continuous registration, or you say that is not the case?
That affidavit, my Lord, is it the affidavit that was introduced in reply to the
No, there was an affidavit. There was an affidavit that was filed in the High Court.
My Lord, that affidavit did not provide actual data or information about evidence. I can come here and say that I have been reading 10 judgments a day as proposed by one of our seniors, Steve Ogola, but nobody can establish whether indeed I have been reading 10 judgments a day. Now, I would be more convinced by the Gazette notice that was brought into this court indicating the numbers of registered voters as at that time. And my Lord, it is a matter of public notoriety, really, that there has been no voter registration.
All right, please move on.
My Lord, the appellants have an issue and seek that this court overturns the finding of the High Court that no referendum should take place until there has been mass voter registration, nationwide voter registration. And they say so, this was their submission yesterday, that before the IEBC receives the notice or receives the bill from the president, that issue is not ripe. That was their submission. That they cannot begin voter registration en masse before they receive that notification and actually know that there's going to be a referendum. But what does 5(1)(a), 1(b)(a) say, my Lord? Registration of voters and revision of the register of voters under this act shall be carried out at all times except, when you go to BA, in the case of a referendum, between the date of the publication and the date of the referendum. Move with me, my lords, to section 49 of the same Elections Act, part 5 on referendum. And this is what it says at 49(6). Here I am assuming, my lords, I'm going with the argument that the commission made that these provisions are sufficient for governing the referendum, whether it be a constitutional referendum or an issue-based referendum. So move with me with that, and let's assume that we will apply these provisions to the constitutional amendment bill. And this is what it says: the commission shall conduct the referendum within 90 days of the publication of the question. Now, if the commission is to conduct a referendum within 90 days of the publication of the question, and 51BA states that no registration of voters can take place once the publication for the referendum is done, when really does the IEBC want all these Kenyans who are eligible to be registered as voters to be registered? What fault do they find in that holding by the High Court that they must undertake voter registration before a referendum? They are saying they can only do that after they receive that bill from the president. Yet the very provisions that they wish to rely on, should there be need for a referendum, provide a 90-day timeline and the date of publication. It cannot be, my lord. That ground must fall. Public participation. The IEBC, among the other appellants, insisted that it is the plebiscite where the people participate. That is the heart of public participation in a popular initiative. We submit, my lord, and I will not extensively submit on what John Locke and Montesquieu provide in the Two Treaties and the Spirit of Laws, Volume 1, page 240 to 296 and 339. It is our submission, my lord, that public participation is an incidence of the social contract, and it need not be textualized under 257 for it to be effectuated, or for the right to inhere upon the people. And my lord, it is important that we look at the JLAC report and what it said about public participation. Volume 4 at page 1375 to 1559. That's the entire report. But on the question of public participation, this was the recommendation at paragraph 409 of the report at page 1495.
Yes.
I'll read it, my lord. 409. There was need for Parliament to put in place a legislative framework on public participation at both the national and county levels of government.
Where are you, Council?
This is volume 4.
You say page 409, eh?
14, paragraph 409 of the report, but page 1495. 1495.
Yes. Please go on.
The Houses, further, in the absence of specific provisions under Article 257 of the Constitution, provisions should be included in the proposed law or in the standing orders of the Houses to provide for public participation in the processing of a constitutional amendment bill by popular initiative.
Yes.
My lord, we move on to publication of that bill. Page 1501 at paragraph 437. It was observed that in order to avoid any question arising on the authenticity of a bill for an amendment of the Constitution by popular initiative during the processing of the bill at the various stages, a legislative framework ought to be provided for the publication of the bill. Paragraph 437, page 1501. My Lord, an amendment proposal through the parliamentary initiative cannot be placed before the House for the second reading within 90 days of its first reading. That is in the standing orders of Parliament. And that was the basis of the controversy in Parliament on whether or not, as Parliament considered the current BBI bill, whether or not that would apply, because the standing orders specifically term it to apply to a bill for amendment of the Constitution coming from Parliament. Now, my Lord, Justice Tuyot took concern with the shortened period of 5 days given to members of the public to confirm the list that had been put up by the IEBC of supporters of the initiative. The amendment bill went through Parliament within a month, all 3 readings, committee stage to the readings. It was submitted here that what is not expressly prohibited is allowed. To suggest that to protect the rule of law, to protect order, to protect the interests of the people, to allow them to participate in this process, we must write it down. Parliament proposed that there must be legislation to provide for these gaps that we all seem to see in the process of the popular initiative constitutional amendment. We submit that the Superior Court was proper to find that it was necessary for legislation to be put in place for collection of signatures, for verification of the same, for the same to be taken through public participation, for the people to be involved, not in 5 days or whimsically, depending on which body is making the decision at which time, but so that we all know, all of us, tomorrow, should Esther Angawa wish to amend Article 257 of the Constitution to ensure that we can no longer amend the Constitution, I should know that this is the way, these are the rules of the game. We find no fault in that decision, and we urge this court to uphold it. Finally, my Lord, I will deal very quickly on the question of referendum questions as I conclude, and I'll take you to Section 51 of the Elections Act, which was submitted to be sufficient. And this is what Section 51 says, subsection 1, where a referendum question requires a yes or no answer, persons intending to campaign for or against the referendum question shall form such national referendum committees and constituency referendum committees as are necessary. 2, where there is more than one referendum question, persons intending to campaign for or against each referendum question shall, on the application to the Commission, form one national referendum committee each and one committee each in every constituency for each referendum question. It is not in doubt that the wording in Article 257 is in singular, a proposal for the amendment. Now, let us assume the Commission will apply this section, even where there are many questions, more than one question. A campaign must be for each referendum question. It is our submission that each amendment proposal in the bill even if the same were to be subjected to this section of the Elections Act, would have to be reduced to one referendum question for each amendment proposal. And my Lord, to help us understand why this is important, the need for one, I'll refer the court to volume 6 of our bundle. At from page 2141 to page 2160, is text by George Lutz speaking on Switzerland, which has been extensively cited, particularly by the BBI and Raila Odinga, the former Prime Minister, as the epitome of citizens' initiative. And my Lord, I refer you to page 2148. In the event I forget, my Lord, I would urge the court, and my ladies, I would urge the court to read this entire writing, piece of text, to understand the difference between the popular constitutional amendment in Switzerland and in Kenya. It's quite different from what the appellants wish the court to understand, but because of time, let me just take you straight to 214 at the second paragraph. That should be line 10. The first, under the Swiss constitution, it is their parliament to decide first whether an initiative is contrary to international law or does not comply with the requirements of consistency of form and of subject matter, and if the parliament finds so, then it invalidates that initiative. But these are the grounds that are given, and the reason why there must be a single issue in a single initiative. The first is the requirement of consistency of form and of subject matter, which means that there should not be more than a single issue in a single initiative. For example, one cannot combine an increase in taxes with a limitation on the number of foreigners in the same initiative, because a voter may be in favor of one but against the other, and as a consequence cannot really vote yes or no.
Yes, please proceed.
In conclusion, my lords and my ladies, we submit that the finding of the High Court, based on our Constitution, and further supported by the Elections Act, the provisions of which the appellants submit should govern a referendum, demand that each amendment proposal must be in a separate referendum question. And on each referendum question, my lords and my ladies, the Elections Act demands formation of committees. And what are these committees for? Those committees are to campaign for or against at the national level.
So
and
that was section what? Two?
That was section 51.
51?
2.
Yeah, 51-2.
Yes. 51-2. One as well, my lord.
Yes.
And the point I wish to make there, my lord, is that we cannot take public discussion, public engagement, public participation outside this process to the ballot as proposed by the appellants. It cannot be an issue of the ballot. That is not where public participation inheres. That is the conclusion of a process that must involve people throughout. And that section 51 is important. That is what those committees are for those discussions. And I dare submit, my lord, those committees seated together with people is an aspect of the Constituent Assembly as they sit and discuss those issues. This amendment, why do we need a prime minister? Why do we need a 7-year tax break? All those are happening in a space of discourse between Kenyans. It is not public participation at the ballot. And the High Court was proper in finding that public participation, civic education, I think perhaps when we use big words, maybe we feel that we're not saying the same thing. When you're campaigning against something or campaigning for something, what would convince my senior Mutuma here? How would I convince him that this is the reason why you should vote for a prime minister? Or this is the reason why you should vote for the judiciary ombudsperson? We must have a discussion. Civic education may have been made a fancy affair by NGOs and civil society and all of that, but it is more than that. And if those provisions on the referendum submitted by the Commission should apply, I see no reason why the appellants have an issue with the findings of the Superior Court. None at all. I rest.
Thank you very much.
I will need the podium, my lord. I'll need the podium.
This is Mr. Mutuma
for the 19th, 20th, and 21st respondents.
19th, 20th, and 21st.
What are the names?
That's Third Way Alliance Party, Miruru Waweru, and Dr. Angela Muikali. Those are the petitioners in the High Court and the respondents in this matter.
Right. Thank you, Mr. Mutuma. Considering that Mr. Harvey and Ms. Angawa have covered very good ground, how long do you require?
We've actually managed.
Without necessarily having to repeat the very same arguments. What is reasonable for you?
My president had donated the remaining 10 minutes, but we can stick to our 2 hours for 2 reasons, my lord.
No,
is that we will have to...
We will adopt the Kipkosgei formula. The 10 minutes were donated to the court.
Much obliged. I stand guided, my lord. So the 2 hours are enough because we'll have to talk about at least 2 issues.
And I suggest actually you take shorter than 2 hours because looking at even your submissions, and the submissions filed by the first to fifth respondents, lots of similarities on the issues. So you really do not need to take 2 hours.
Thank you, my lord.
Can you try with 1 hour?
1 hour is not possible, my lord, because we have the JLAC report to cover that my senior, Professor Kindiki, will have to talk about. It's quite
let me just
ground to cover.
Sorry, can I have the submissions? Yes, proceed.
Thank you, my lord. Let me begin by introductions. My name is Elias Mutuma. I appear for the 20th, 19th, 20th, and 21st respondents in the matter. Those were the petitioners in petition E400 of 2020 at the High Court. We have filed the following documents that we seek the court to look at in support of our response to the petition, to the appeal rather, that we are opposed to. Our submissions are dated 23rd of June 2021. We have an affidavit sworn by Miruru Waweru pursuant to the leave granted by this court. The same is dated 25th of June 2021, principally introducing the JLAC report and the Hansards. We have our list and bundle of documents, authorities rather, with the case summary dated 23rd of June 2021.
Yes.
We also rely on our pleadings at the High Court that are found at volume 4 of the Attorney General's Records of Appeal from pages 1410 to 1679. Now, our mode of presentation, my lord and my ladies, is that I will talk just a little bit about the basic structure in as far as I understand it. We'll also talk about the popular initiative to this extent, who is allowed under the Constitution to initiate a popular initiative, who did initiate the impugned popular initiative that we are talking about, what was the threshold or the role of IBC in this whole affair. We will also talk about public participation in that light, especially on the evidence that we relied on at the High Court. Finally, my learned senior, Professor Kindiki, will handle the JLAC report.
May, Counsel.
Yes, Your Lordship.
Listening to the things you intend to address us on,
Yes.
I don't at all want to take the wind from your sails.
Yes.
But truth of the matter is, for the last 3 days, basic structure has been uttered in this place for like what, 100 times? I sleep at night and I just hear basic structure in my head. It might be useful unless you have something really new.
I do, my lord.
Just a minute. Unless you have something really new about it, just say you agree with somebody's submissions because it has been said before. That will save us a lot of time.
I do have, my lord.
Thank you.
Thank you. First of all, let me talk about an issue that has been brought by the appellants about the justiciability of the petitions in the High Court, because it was submitted that the petitioners in the High Court brought before the court an issue that was not ripe for determination because there was no real dispute that the court was invited to address. We beg to differ, my lords and my ladies, in that we as the petitioners thought that there was a threat to this constitution. We invoked the jurisdiction of the High Court under Article 165 3D for both interpretation and enforcement of rights. Now, my lords, whereas the rest of us only have an obligation to defend this constitution under Article 3, I do submission the constitution has given you authority to defend the constitution. The rest of us do not have that authority. So it is my submission that we brought a real issue touching on a dispute on a threat to this constitution. I do not see any other situation that the constitution envisaged being defended like the instant case. In fact, I have always thought since the time we began these petitions that Article 3 was made for this particular purpose, not for any other purpose. Because this is the only time when the constitution is directly under attack. I urge your lordships and my ladies to exercise your authority and defend that constitution. On the issue of basic structure, my lord, I do agree that the words that have been used are in no doubt very fancy, technical in nature, that only legal scholars will understand what a basic structure is. My learned senior and President Harvey is so good with philosophy. I am not. So I will not go philosophical about it, my lord. But to me, I look at the basic structure and what comes into mind is changing an existing law. And there are only two ways of changing an existing law. And I'm using the word changing deliberately, not amending. There is a repeal and there is the amendment. But the two ways are acceptable legal ways of changing an existing law. Now, the effect of amending, and these are not my words, I went looking for the definition of amend at the Black's Law Dictionary, 9th edition. At page 94, it says, to amend is to make right, to correct, to rectify. Second meaning is to change the wording of, formally alter a statute, constitution, or motion by striking out, inserting, or substituting the old one. So when the Constitution talks about amending, that is what it has in mind. To make it right, to correct, to rectify. The second meaning, or rather the second way of changing a law, is to repeal a law. I went looking for the same definition in the same source, and this is how it defined repeal: to rescind, to abrogate an existing law by legislative act. Now the question is, does our constitution envisage a repeal of itself? Or it only anticipates an amendment to itself? I have gone through the constitution. There is no mention of a repeal. And there are two ways of repealing. One is by specific declaration in a new statute or main motion. That is, you have to declare it outright that we are repealing, we are doing away with it. That is express repeal. The second, as per the same dictionary, it is implied repeal. Repeal by irreconcilable conflict between the old law and the new law. So the question is, the BBI initiative, is it amending or repealing by implication? If it is repealing, there is no provision in our constitution of repealing, either expressly or by implication. And that's what we are talking about. If you do not find any clause in the constitution allowing a repeal, then you must say that we have our constitution for eternity. That is what it means, that we cannot repeal it. You cannot therefore go and seek refuge.
Sorry, come back on that statement. If there is no what?
My Lord, my summation is that
Yes.
there is no anticipation of a repeal in our constitution. It does not anticipate a situation whereby it will be replaced, either expressly or by implication. I have taken a lot of time to explain what that means, implication. So then it means the constitution as it is envisages a lifetime, an eternity. We cannot therefore go to Article 255 and seek to repeal the constitution either expressly or by implication. So if then the nature of the changes that are being brought are such that they bring about irreconcilable conflict between that what we have and that what we are bringing in, then we are repealing, we are not amending.
Counsel.
Yes.
I'm just wondering, you talked about fancy terminology,
Yes.
right?
Yes.
Do you think eternal and eternity clauses is a fancy thing? I mean, really, who knows about eternity? Nobody has ever been eternal. Are we saying the Constitution contemplates that it is perpetual? Would it have the same meaning as what you're calling eternal?
My Lord, what it means basically is that within the confines of our current constitution, we cannot repeal it. If we must go beyond 255, 256, and 257. And that is what the learned judges were saying in simple. Go back to the Njoya case. That you must now start looking at a process that is not envisaged under 255. Involve the people directly in a manner that they are amending, or rather they are creating a new document altogether. That is what I'm saying. So eternity means...
Your colleagues on the other side have a problem with eternity. I mean, you had them. And I think that, well, I too would have a problem with eternity. What exactly does it mean? Would it be the same meaning if you called it something else other than eternity?
Yes, my Lord, I would say this. Eternity in this case means for as long as we have it, the document that we have. Beyond that, then, it's not eternity. And we must go beyond, if we must repeal, we cannot seek refuge under 255, because that is not an amendment, rather it's a repeal of the Constitution. I hope, my Lord, you've seen that I have a different approach on the basic structure so that I do not seem to repeat what...
Could I just follow that up?
Yes.
The definition you have given from Black's Law,
Yes.
does it accord with the definition in the Interpretation and General Provisions Act?
I must confess that I haven't looked at that, my lord, but then if we must really understand what basic structure is, we must seek to get several and different definitions for us to really understand. So the question would be, do we have an implied way of repealing rather than the express one? If the answer is yes, then we must settle that 255 is not the answer when you seek to repeal the Constitution, either expressly or by implication. My lord, let me move to...
Mr. Mutuma,
Yes.
if I get you right, what you're saying is that our Constitution provides for the amendment of the Constitution, but it does not provide for repeal.
Correct, my lady.
So we have to look outside this Constitution if we wanted to repeal it.
That is my argument, my lady, so that if, for example, today we got tired of this Constitution that is eternal, we have a mechanism, but it cannot be found under 255 or in any of the provisions under this Constitution. Just like we did prior to 2010, we could not have gone back to the Constitution. We had to go outside that and replace the existing norm with another norm. That is my argument. If I may then move to the issue of popular initiative. My lords and my ladies, Article 1.1 of the Constitution talks about sovereign power, not just sovereign power, but all sovereign power belonging to the people. This is power that can be exercised directly or indirectly, and we have heard that story many times. But the question that has not been said, rather the question that has not been asked, what is this power that the people must exercise, or that the power that belongs to them? I submit that there are only three powers capable of being exercised, directly or indirectly. One is the executive power, judicial authority, and legislative authority. Those powers belong to the people. They can be exercised directly or indirectly. Now, the people donate those powers to their democratically elected representatives, and they are exercised on their behalf. But they still reserve the right to exercise them directly. Now, for the purposes of this appeal, I'll not talk about executive power or judicial authority in terms of powers envisaged under Article 1.1. I'll talk about legislative authority. So we are in agreement that indeed that power belongs to Wanjiku, the people. So is there a place in the Constitution where the Constitution envisages that Wanjiku will exercise legislative power directly? That is the question. And before I move to that, to the answer to that question.
And as you do so,
yes, Your Lordship.
Can you attempt to define the people? Are you included in the people?
Indeed, my lord, I am the people. We are the people.
Am I included in the people?
You are.
So what is your definition of the people?
The people is, in fact, the Constitution does not talk about the people. It talks about the people of Kenya.
Yes.
Right? So if we are in Kenya, citizens of Kenya, living in Kenya, we are the people. But then, my lord, when we the people collectively donate our powers to you individually to exercise on our behalf, you cease to be the people. So that now you're exercising powers on our behalf. So you cannot, unless you relinquish that power that we've given unto you, then you come back to our fold and now you remain as the people. So we give you authority as the judiciary. We give you authority as the legislature. We give you authority as the executive. So you cease at that moment being just the people, but we elevate you above the people. That is what. So there is a moral higher ground for the person to whom authority is donated.
And I speak about an issue that affects me as an individual and not as a judge.
Indeed, my lord, and we have seen that happen time and again, that once you leave the bench and you walk home, you do not walk home as a judge. You do not exercise your powers as a judicial officer to your employees, to your neighbors. You remain an individual. So you will have to tell us, and let me just give an analogy, my lord. The government and the people are gracious enough to facilitate the movements of the people we donate power to. Government vehicles. When you're on official duty, there is a flag to your vehicle. When you're not, I have seen judicial officers covering that part, symbolizing that now, this is not me the judge, this is me the person. So you must somehow put that crown down and now become the person. It must be known that the person speaking now is not the person to whom authority has been donated or not. That is my argument.
Thank you.
So, my lord, then, as the Constitution envisaged that the people will exercise judicial authority, or rather legislative authority, the answer is yes. The people to whom legislative authority has been donated is the legislature, parliament, not the executive, not the judiciary. So the judiciary cannot purport to exercise legislative authority, neither can it purport to exercise executive authority, because that has not been donated to you. Neither can the executive purport to do that. And to answer the question that was posed by the bench, in a situation where the president feels he does not have the majority in parliament and feels somehow crippled, I would then suggest that is actually the essence of separation of power. Because the president is not in the business of legislating. That is the business of legislature. So he should not even be seen to bulldoze parliament, because that is not his business. So then, the people, how do they exercise legislative authority? Let's go to the preamble of our Constitution. And my president read that part, but there is another angle I want to bring into it. At the end, it says, we the people, having talked about a lot of things, exercising our sovereign and inalienable right to determine the form of governance to our country, and having participated fully in the making of this Constitution, participated fully, not partially, not indirectly, but fully. There are two words that go after, my lords and my ladies. Adopt, then immediately enact. They do not just adopt, they adopt that which they have enacted. So the key word there, and I want you to take note of the arrangement, is adopt coming after enacting. So then, at the preamble, we are clear that we, the people, have legislative authority, and we can exercise that power directly by fully participating in the constitution-making process. Let us jump to the elephant in the room, 255, and see what it says. It says, and I read, a proposed amendment to this constitution shall be enacted. The word again appears, enacted, in accordance with Article 256 and 257. And then what happens? Approved. The preamble talks about adopting after enacting. 255 talks about enacting, then approving by way of a referendum. So let's not confuse the two terms. You enact, you adopt, you approve. Rather, you approve, then you adopt. That is the sequence. That is found, again, under 255(3), that an amendment to this constitution that does not relate to a matter specified in clause 1, again, shall be enacted, not approved, not adopted, but enacted. So the instructive word is enact. Either by Parliament, and Article 256, or by the people and Parliament, in accordance with Article 257. So who should be involved in the process of enacting the Constitution? For the purposes of Article 255b, it is the people. In exercise of their legislative powers directly, without involving any other person, without donating, they have receded their authority given to the legislature, and they are exercising that directly. So it is enactment, then approval by way of a referendum. What the appellants have been telling us is that our role as the people is only to be seen at the approval stage, that is the referendum. So then the question is, who has enacted this law? And 257 is the only instance in this whole constitution where the people have reserved the right to enact, to legislate. There is no other. So could it then be said that under Article 1, that authority was pronounced in vain, that we have legislative power but in vain? We must be seen to exercise that authority at this juncture, 257. Let me go to Article 257, and again there has been a misunderstanding of 257 in my own understanding, that the initiative begins with their million signatures. A term is different. The term that is used there is very different. An amendment to this constitution may be proposed, not enacted, but proposed by a popular initiative signed by at least 1 million registered voters. So what they are proposing here is making it formal, what they have already enacted, what they have already created under the sovereign power. Because even in Parliament, a bill is presented for reading, a bill that has already been enacted by Parliament. Then it is read. A proposal is put on the table. So the 1 million signatures is not for the purposes of creating, it is for the purposes of officiating a process that they have already begun as the people. So when then the appellants come here and tell you that it doesn't matter where those proposals come from, that you only need to gather 1 million signatures and present, they are dead wrong. They must be told that. We submit that a popular initiative must begin with the people by way of enacting, then officiated by way of proposing, or rather endorsing, by 1 million signatures.
Who will do the enacting?
The people, my lord.
Tell us the methodology.
And that is why basic structure comes in. That you must have involved the people as per the preamble, fully participating in the process of enacting that document.
Mr. Mutuma, I'm not saying you are wrong. I want to understand, minus the legislature, without the legislature, how will the people enact?
Indeed, my lord. And that is why, under 256, 4, it says that what can be presented to IBC could be in form of general suggestions, then converted into a bill. The people are powerful. The people are capable of drafting. In fact, if we were to go by the assertions of the appellants, this was drafted by Dennis Waweru and Junet Mohammed, the two of them. That's what they want us to agree. So that it should not be a problem for us to enact a law. In any case, this was done by 2 individuals. That is what they're telling us. So we have the capability.
Mr. Mutuma, I don't think we were told Junet Mohammed and Waweru enacted, but that they were the promoters.
I agree, but we have not been told what the enactors are, and that is even our greater problem. And that's why, subsequently, we will show that the executive was involved all through. So, but my point is this. It will not be difficult for the people to enact, because we the people are lawyers, we the people are judges, we the people are drafters of the Constitution, as long as they are fully involved in the process, because that is it, enacting.
Did the legislature play any part in the birthing of this Constitution?
The current one, yes, my lord. But in a popular initiative, their role is merely ceremonial. They do not in any way involve. But there is a point I'm trying to make here, that at that juncture of enacting, it must be seen to be a process by the people.
All right,
and I do not doubt
okay,
the people's capabilities of drafting a bill.
Move on, Council.
Yes. So my lord, then, it is not in doubt that a popular initiative can only be enacted by the people, proposed to IBC by the people, and approved finally at the referendum by the people.
Mr. Mutuma, I think you need to get that sequence right. According to you, the sequence is enactment followed by proposal followed by?
By approval. And approval is in 3 stages. At the county assemblies, there is a threshold. At the National Assembly, at the Senate, then finally at the ballot by the people. Those are the instances.
Isn't enacted really an all-encompassing term that refers to that entire process, from the moment there was a proposal, preparation of a bill, approval, so that in the end, when it's done, you can say it has been enacted. But if you say that you begin with enactment, then a proposal, what form does enactment take?
According to the definition of an enactment, again, I'll go back to the Black's Law Dictionary, the same definition, is to make law, to pass law.
Exactly, and
yes.
it is not enacted until it has come into being. But in your sequencing, you say it is enactment followed by proposal and approval, and that is getting me a bit confused.
A proper reading, my lord, of Article 255 talks about those 2 processes, enactment and then approval. So it cannot then be that enactment is the final product when the Constitution talks about enactment by Parliament and approval by way of a referendum. So there is a distinction right from 255 that you enact, then you send that which you have enacted for approval by way of a referendum.
But if it is in accordance with 256, and 256 talks of a bill, are you saying surely the legislature is not the one that is going to formulate this bill?
My lord,
Because 255 says in accordance with 256. And 256 says a bill to amend this constitution may be introduced in either house of parliament.
Yes, under 256, my lord, Parliament has the right to enact.
No, I'm saying
Yes.
255 is a proposed amendment to this constitution shall be enacted in accordance with Article 256 or 257. And 256 talks of a bill to amend this constitution may be introduced in either house of parliament.
My understanding, my lord, of the role of parliament at 255 3b is that at the end of it all, we will see parliament either approving, then it becomes the final product if it does not involve the protected clauses under 255, then they will now enact and approve at that juncture.
Right.
Yes.
Please move on.
Thank you.
Before you move on, now since your stand is you are faulting the process, and that is why we are all engaged here. Just for for me to understand, for me to understand you better and move on the same wavelength. In a minute or in a second, according to you, and you are going to explain to us what should have been the correct procedure in line with the definitions that you have given us, just for me to understand so that we move together.
What I was trying to establish, because that was the appellant's case, is that it does not matter where the promoter of the popular initiative gets the proposals from. That was my argument. My argument is that a promoter from nowhere does not become the initiator of a popular initiative merely because they have brought 1 million signatures. So they must be able to establish that the people have been involved fully in that process. And now I am moving to my second and last part. I see I only have 29 minutes. My lord, then, with that understanding in mind, who then initiated this process? Because we have seen the executive cannot initiate because they have not been given legislative authority. That has not been donated to them. Parliament has also not been given authority to legislate under 257. Theirs has been reserved under 256. Then, where did we get this impugned constitutional amendment from? My lord, the appellants have come before this court. They have advanced 3 theories, and I call them theories because they come from different appellants. The first theory is that this was an initiative by one Dennis Waweru and Junet Mohammed. That has been submitted. Now I find that to be, for lack of better terms, taking us for a ride. So instead of them coming here and owning up, coming out clear to tell us who the promoter initiator was, they have told us these 2 individuals promoted this initiative. The second theory is that it is not Dennis Waweru and Junet Mohammed in their personal capacity, but an entity known as BBI National Secretariat. The other theory that has been brought to your attention is that it could be, and I'm using the word very carefully, because that came out, though not very expressly, that's why I'm calling it a theory. It could be the president, either in his official capacity as a symbol of national unity under Article 130, 131, and there is nothing prevented him from actually initiating a popular initiative. Or on the other hand, it is the president, but not in his official capacity, but as a person who also enjoys rights under the Constitution. My lords and my ladies, the impugned amendment process must be viewed as a direct product of the handshake that we all know about. Those facts are not in dispute. At the steps of Harambee House, between His Excellency the President in his official capacity and Right Honorable Raila Amolo Odinga. We submit that though the handshake was packaged as an initiative to promote national unity, cohesion, fostering cohesion and bringing about unity, it was a Trojan horse. A Trojan horse packaged as a unity package by the state to use executive powers to amend the Constitution. And let me pause there and address an issue that I know I might forget to. When the handshake happened, my client, Third Alliance, proceeded to the High Court and filed petition 451 of 2018. You have been told that you declare the petitions in the High Court res judicata on account of that petition, 451 of 2018. Now, after the handshake, my clients were apprehensive that this is actually a Trojan horse. And they moved to the High Court and sought for declarations to declare the establishment of the task force as illegal. We filed that matter in 2018. The declarations we sought were only to declare the establishment of the BBI task force as unconstitutionally constituted and disregard its report. At the time, suffice to note that we do not have the BBI steering committee. Justice Mativo looked at the terms of reference of the task force and found nothing wrong with the terms of reference, and that the president was within his powers under Article 130, 131 to foster national unity and establish a task force, but only to the extent that it was going to advise him on policy issues. You will note from that Gazette notice that there is nothing mentioning amendment of a constitution. So we agreed with Justice Mativo 100%. That's why we never appealed. So to say that this matter is res judicata is not correct. The parties were different. The principal party there was the Building Bridges Task Force. It is not a party in these proceedings. The issues were different. It did not touch on the amendment of the Constitution. So it cannot be said that it is res judicata. Now, was it Dennis Waweru that initiated this process? In our petition that we filed in the High Court, we made a description of the parties that we sued. Because the first party that we sued was the Building Bridges Steering Committee that had been established by way of a Gazette notice dated 10th of January 2020. Now, we also sued the BBI National Secretariat, and this is how we defined them. The first respondent, and I'm looking at pages 1477 of the AG's Record of Appeal, Volume 4, that the petitioners, that the first respondent is the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force established by the President of the Republic of Kenya by way of a Gazette notice dated 10th of January 2020. The second respondent in our petition was the BBI National Secretariat, which we defined as follows: as an administrative department of the first respondent. The said secretariat, in our own description, is co-chaired by the following individuals. One, Honorable Junet Mohammed, who is a member of National Assembly under the ODM ticket, and Honorable Dennis Waweru of the Jubilee Party. That is how we describe them. Now, after being sued and served, the first and second respondents instructed an advocate, Messrs. Paul Mwangi and Company Advocates, via a notice of appointment dated 10th of December 2020. It's to be found at page 1741 of the Attorney General's response, Records of Appeal, volume 5. He entered appearance for the respondents, who is the BBI Steering Committee and the Secretariat, not Junet Mohammed, not Dennis Waweru. Now, according to the submissions filed by the appellants at page 37, this is the BBI's submissions. They fault the High Court for making the following orders: that it is evident from paragraph 529 of the impugned judgment, the landed judges fundamentally conflated the roles of the task force and the steering committee on the one hand with that of Honorable Junet Mohammed and Dennis Waweru. This is very important. Trading in the name and style of BBI National Secretariat. So what they are telling us is that BBI National Secretariat is a business entity owned by Junet Mohammed and Dennis Waweru. That is in their submissions. Let us contradict what they said in their response in the High Court. They filed a response to our petition. That replying affidavit is to be found at pages 1755, again, of volume 5 of the AG's Records of Appeal. This is very interesting, my lords. Dennis Waweru swears an affidavit dated th of February. At paragraph 1, he says, "I am the co-chairperson of the Building Bridges to a United Kenya National Secretariat, and my co-chairperson being the Honorable Mohammed Junet, together with Honorable Junet Mohammed, duly authorized to swear this affidavit on behalf of my co-chairperson and on behalf of BBI, Honorable Raila Amolo Odinga, the respondents in this case." My point is, the respondents in that case was not Junet Mohammed, was not Dennis Waweru. We sued them in their capacity as officials of BBI National Secretariat. They never filed a single notice of protest to that description. They in fact confirmed our position by way of an affidavit that they are co-chairperson of that entity. At paragraph 3, they say, describing now the respondents, rather the BBI initiative, that the Building Bridges to a United Kenya was created and mandated with the task of initiating constitutional amendment process and unifying Kenyans, among other functions. They confirm it in their own pleadings.
So what is your bottom line, Counsel?
My bottom line,
following that argument.
my bottom line,
Yes.
my lord,
Yes.
is that Dennis Waweru, Junet Mohammed cannot be said at this juncture to be the initiators of this process. It must be seen as an initiation of the BBI National Secretariat, which is an administrative body of the BBI Building Bridges Steering Committee. That is my point.
All right.
And to cement that fact, because it has been said, and I had my learned friend, Senior Counsel Otiende Amolo, saying that as at 30th of June 2020, the BBI Steering Committee was not in existence. That is what they said. It is also captured in their submissions. As of 16th of October 2020, months after 30th of June 2020, when it is said that the BBI task force was not in existence, that is when the BBI steering committee was handing over the report to the president at Kisii State Lodge. We annexed that in our affidavits. In their forward, dated 16th October 2020, they say that, and it is addressed to Your Excellency the President of the Republic of Kenya, that you appointed this steering committee by Gazette notice published on 30th January 2020, and they state the terms of reference. I do not want to rehash them. But at the end, what do they present to the President on 16th of October 2020, when apparently they were not in existence in accordance to the appellant's case? The result is the following: 1, policy; 2, administrative; 3, statutory and constitutional instruments that address the national challenges outlined in the joint communique of the Building Bridges Initiative. It is in this report where the impugned, and that is now the gist of this case, it is in this committee, this report rather, where the impugned BBI, that is the Constitutional Amendment Bill of 2020, was attached to that report. That evidence again was produced. I invite you to look at the affidavit of Mirodu Waweru, sworn on 3rd of December 2020. That report is signed by all the members, in the next page, of the steering committee appointed by the President, including my good friend, Mr. Paul Mwangi. His signature is here as a joint secretary. So they are the people who drafted, that's my point, who enacted this piece of legislation using executive authority by way of a Gazette notice. That is the point that I was interested in making. In fact, looking at the bill itself, it does not in any way mention the so-called promoters. At volume 7 of the AG's record of appeal at page 2534, that bill, the Constitution of Kenya Amendment Bill 2020, dated 25th November 2020, was number 1, most importantly, printed by the government printer. At the end of it all, it is said the promoters at the end, to be found at page 2576, are the following: Building Bridges Initiative, stroke promoter. It is there in that bill. So when then the appellants come here, tell us what they did not tell the High Court, that they were indeed, that indeed it was promoted by Dennis Waweru and Junet Mohammed, it is an outright lie. It cannot be allowed to pass. Parties are bound by their own pleadings. My lords, having established that indeed it was the executive that initiated this process, and having also established that the executive is not allowed to initiate a popular initiative because that power has not been donated to them, I submit that the impugned bill is unconstitutional. It is not a popular initiative. It is a presidential initiative. And to go back to the question that Your Lordship, the President of the Court of Appeal, asked me, whether once we donate once we donate sovereign power to you, do you still have individual rights? Like the President would want us to agree rather, yes. And like I said, you must avoid declothe yourself of executive authority, then become a citizen. I'll give you an example that happened with this same executive, Your Lordship. In 2014, our president was facing a personal case at The Hague. When he was leaving for that case, which was his personal matter to attend to, he did the right thing. And I believe, under the advice of Emeritus, AG then, Professor Githu Muigai, he handed over power to the deputy president, appointed him as the acting president, went to The Hague as a citizen, was not received by the state there as a president, but as an individual. So if the president then wants to initiate such a process as a citizen, he must of all do exactly that. Announce to us that this is not the president doing this, it is me as a citizen. I see my time is running out. I have my colleagues to submit on a few issues. I submit that the appeals before you are not merited. The same should be dismissed. The court ought to uphold the judgment of the Superior Court. I'll invite my learned friend, Carol Gerono, to just address on a few issues. Thank you, my lord.
Thank you, Mr. Mutuma. Please introduce yourself, and I hope you know you have like 10 minutes. Because we'll adjourn at 1:30.
My lord, my name is Miss Caroline Gerono. I appear alongside Mr. Mutuma and Professor Kindiki for the 19th, 20th, and 21st respondents.
With your permission, my lord, could I seek a clarification? This court gave directives earlier on that each of the respondents will have 2 hours, and put a caveat that there should be no repetition. My lord and ladies, this matter is so monumental. I want to plead with you, even as my colleague finishes her time, that you allow us to do our 2 hours. There will be 0 repetition, and I believe will be of help to the court. And so, my lord, I did a directive so that you can guide us as we go for lunch.
Are you talking of, Professor Kindiki, you talking of 2 hours over and above what has been taken by your other 2 colleagues?
No, my lord, 2 hours cumulatively. I know we will be spending 1 hour by the time we go on recess, on adjournment. So I'm kindly requesting with tremendous humility if we could have the extra 1 hour after lunch.
1 more hour?
Yes, my lord.
Ms. Cherono,
Yes, my lord.
would you, in the remaining 9 minutes, have finished your bit?
No, my lord. We had apportioned ourselves that I would do 30 minutes. So I would suggest to the court if we would adjourn for lunch, then we have 1 hour uninterrupted shared between me and between Professor Kindiki and myself.
Can we give Caroline Cherono like 15 minutes and Professor Kindiki for 30 minutes, a total of 45 minutes? We can adjourn now so that you are able to, put your thoughts better. We'll try to accommodate with the request that you've made.
Sorry to come back on this, my lord, but the appellants each had 2 uninterrupted hours, and they will also have a bite at the cherry because of the right to reply. It is only fair, my lord, that you consider giving us, as a team, 2 hours, and how we share it, we can leave it to the internal mechanism.
Okay, then let us do this. Let us adjourn now, and when we come back, we will see what happens. We hear what you've said, Council. After 1 hour precisely.
Kameme TV, Muthegi wa Rũrĩrĩ.
Wekira deposit ya ngiri magana kenda towards kugura value added plot thini wa Success Gardens gated